Please be seated. Our next case is Crum Services versus Lopez. Counsel prepared? You may proceed.
May it please the Court, my name is Juliana Curtis. I represent the appellants, Crum Services and Frank Winston Crum Insurance. Your Honors, at this time I'd like to reserve 3 minutes for rebuttal. There are 3 reasons why the Judge of Compensation claims lower court rulings should be reversed. The first of which is the finding that Crum is the appellee's employer is not based on competent substantial evidence contained in the record. The second is that the JCC misapplied and erroneously construed the pertinent and controlling case law and statutes when he found that Crum was the appellee's employer. The third reason, Your Honors, is that this ruling violates public policy. This case involves a roofing company, P&G, which contracted with Crum Services, an employee leasing company, to provide payroll, workers' compensation, and other employment-related services. Under the terms of the contract, these services were only to be provided to leased employees. The term leased employees was defined within the leasing agreement entered into between P&G and Crum Services. And in order to become a leased employee, prior to the commencement of work, that individual must complete an employment application, an I-9, and other employment documentation, and have that forwarded to Crum Services prior to commencing work.
Counsel, does the record reflect that P&G had any employees other than employees at least from Crum?
The record is silent as to whether or not there were any other employees, of course with the exception of Mr. Soto Lopez, that were not run through Crum.
Does P&G have workers' compensation coverage?
No. P&G was an uninsured employer, but obtained coverage for its leased employees through Crum Services. That was one of the employment-related services provided by Crum. Now, at the time of this accident, there was at least one leased employee that P&G had through Crum Services, and that was Daniel Del Sol. And he was a supervisor. He was actually the supervisor who hired Mr. Soto Lopez. He hired him to be a helper on one of the roofing job sites. And it's important to note that it's undisputed that Mr. Soto Lopez never completed an employment application either for Crum or for P&G or any other employment documentation.
Counsel, is there any evidence in this record that Mr. Del Sol was a subcontractor of P&G?
Your Honor, there was testimony from Mr. Del Sol that in the past he had worked as a subcontractor for P&G. However, the record does not support a finding that Mr. Del Sol was a subcontractor. He was clearly a leased employee through Crum Services. They had him on the payroll. P&G was treating him as an employee and not as a subcontractor. Now, Mr. Del Sol was actually the one who, after Mr. Soto Lopez was injured, Mr. Del Sol doesn't call it into Crum, but actually takes him to the medical clinic, pays for the medical bills, and even paid for some lost wages when Mr. Del Sol, when the appellee couldn't go back to work right away. All of this occurring while Crum is completely unaware that Mr. Soto Lopez has even been hired by P&G, nonetheless had an accident on the job. And then, of course, inevitably, Del Sol gets reimbursed by P&G, but P&G stops paying and disappears, and Crum is left as the only defendant once we reach the trial court level.
Counsel, you cited the Labor Ready case, and I use the name Labor Ready because I can't pronounce the name of Mr. Paul
Hazel-Ferrio, I believe, Your Honor.
And in that case discusses the relationship between the employee and the leasing company and the company leasing employees from the leasing company. And at page 603, it quotes from the statute that says a licensed employee leasing company is the employer of the leased employees. And goes on to quote from Larson about sort of a dual role here. Under the rationale discussed there, why aren't both P&G and Crum employers of the claimant here?
Well, it's simple, Your Honor, because there's no, it violates the contract. What P&G did violated the contract between
Why is
P&G and
that the claimant's problem? Why isn't that between P&G and Crum?
Well, essentially, it may be between P&G and Crum, but at the trial court level, the JCC was, he was bound to make a determination as to who this individual's employer was. There was no competent substantial evidence in the record that supported that Crum was his employer. There's only a few ways that you can establish an employee-employer relationship in workers' comp. You either do it that by definition, you do that by contract, or you do that in an equitable estoppel situation. By definition, under 440.0215A, simple remuneration for work performed, P&G is this gentleman's employer, and the buck stops there. But because P&G was an uncollectible defendant, the judge actually went on, because he thought it was unconscionable to find P&G responsible. That's an equitable decision, Your Honor.
But what about the statute I just read from, 468.529, that basically says the employee leasing company is the employer of the leased employees?
And the key phrase there, Your Honor, is the leased employee. Mr. Soto Lopez never qualified as a leased employee because he never met those necessary elements of the contract, which said, you got to submit an employment application, you got to submit these documents to Crum prior to commencing work. If you don't have that contractual requirement in place, it's bound to breed fraud by these employers, which, you know, I venture to say may have been present in this case. It gives these employers carte blanche to run one employee through the leasing company and then hire whoever they want and expect that the leasing company is going to cover them. And that's simply not what the contract said, Your Honor. The judge of compensation claims erroneously believed that he did not have the authority to even look at the contract between Crum and P&G. But that's just simply not true, Your Honor. The case of Fred Stevens Tree Service versus AMS Staff Leasing, and also the case of Tampa Bay Area NFL, both indicate that the judge can look at the contract insofar as it affects an award of compensation benefits. But this court held in Fred Stevens that if the determinative issue is a reformation of that contract, then the JCC has no authority to look at that contract, and it's something that the circuit court should look at. But
now, for purposes of the
yes, Your Honor,
statutory employee relationship, could Crum be considered a subcontractor of P&G?
Your Honor, Crum is not, no. The answer to your question is no. Crum is not a company which is employed in the construction industry. So it could not be considered a subcontractor. In addition, P&G did not take a portion of their contract for this roofing job and sublet it out to Crum Services. Crum Services was completely unaware that this job was even being conducted. So there's no way that Crum Services could be interpreted as a subcontractor.
Counselor, the judge of compensation claims seemed to rely, or did rely fairly heavily on the impermateria interpretation of the three related statutes, one of which makes your client, seems to read to me, essentially for safety conditions.
It is, Your Honor.
Could you address that statute, please? Absolutely,
Your Honor. That is Florida Statute Section 468.525, subsection 4. And this statute states that the leasing contract must contain language that the leasing company has a right to take certain action over its leased employees and the job sites upon which those leased employees work. And Judge Thomas, that's exactly why that's there. That's for safety reasons. That has to give that leasing company some right of control over those leased employees and job sites. However, that is not a mandate. And the administrative code which regulates leasing companies, Chapter 61 of the Florida Administrative Code, Section 61G7-6.001, subsection 11, as cited in the brief, specifically states that the leasing company does not need to actually exercise those rights in 468.525, only that they include them in the contract and retain the right to exercise them, if in case it's needed.
So your client had the authority to go onto the job site and say, the ladder's unsafe, there aren't adequate other types of safety equipment. And would you discuss the other statutes briefly, please, that the judge of compensation claims relied on to reach the result?
Absolutely, Your Honor. The other statute used was Florida Statute 440.11, which essentially describes an employer's immunity for civil tort action in workers' compensation cases. And the judge interpreted a portion of that statute which said the immunity extends to the client company. When you use a leasing company, the immunity extends to the client company. And the judge took that extension and said, well, then it extends for every purpose. And if you continue on to read 440.11, the judge only pulled out that little blurb. If you go on reading, 440.11 subsection 2 actually mandates that the employer shall secure compensation for its employees unless that compensation is secured by the health services supply company. And in this case, P&G knew that Mr. Soto Lopez was not a leased employee. So this 440.11 subsection 2 mandates that P&G is a responsible employer in the situation. So had the judge completely reviewed that statute and not just pulled out a blurb, he would have come to the result that P&G is the responsible employer. That would be a complete construction of the statute. And, Your Honor, the other statute used by the judge to read in pari materia and find an employment relationship was, as Judge Lewis alluded to earlier, the statutory employer section 440.10 subsection 1 subsection B, and essentially that indicates when an uninsured subcontractor has an injured employee, that injured employee becomes the statutory employee of the general contractor. Your Honors, but I submit to you that in this case, that statute should have never even come into play. There are some missing elements for the application of that statute to come into play. Judge Lewis pointed out, one, we know that Crum's not the subcontractor. Well, who's the subcontractor here? Del Sol's not the subcontractor because he was an employee of Crum and P&G. Was the claimant, so we're left with, was the claimant a subcontractor? The evidence below, Your Honors, does not support that finding. Mr. Lopez was hired by Mr. Del Sol on a daily basis. He was going to pay him daily, not at the completion of a job. He was hired as a laborer, not for some skill that he has, and he didn't even have his own tools. So the element necessary to kick in the statutory employer section is not present. And therefore, it should not be applied. What should have been done in the situation was a simple review of the contract, as they did in Tampa Bay area NFL, and indicate, well, it says he didn't comply with the contract, he's not an employee. And in fact, the contract itself specifically says, if you don't comply with these, client employer, and all other employees, they're going to be your responsibility. And the contract is clear and unambiguous as to that fact. But yet the judge felt he didn't have the authority to review that contract, but yet then he uses something out of that contract to find that Crum stepped into the shoes of P&G as the general contractor. Your Honor,
you're down to below 2 minutes.
Thank you, Your Honor. The JCC had absolutely no authority to do that whatsoever. The competent substantial evidence supported that this individual is not an employee of Crum Services. It's against public policy to find otherwise. The judge, it amounts to legislation from the bench. It promotes fraud, as I alluded to earlier, and it sends a chilling effect on the PEOs, the employee leasing companies, and the small employers who they actually provide a benefit for. PEOs are never going to work in the construction industry because if you're not the actual employer, you're going to end up being the statutory employer. So it's against public policy. It's going to cause a chilling effect. And it is for these reasons, Your Honors, that the appellants, Crum Services and Frank Winston Crum Insurance, respectfully request that this court reverse the lower court's finding that Crum Services is the employer for workers' compensation purposes of Mr. Ruben Soto Lopez. Thank you.
Good afternoon, Your Honors. My name is Jane Robin Wender, and I'm here on behalf of the appellee. This case actually surrounds a very interesting issue, and it's an issue that has been in front of this court in many different ways over the last couple of years. My esteemed opponent here mentioned two cases, Fred Stevens and Labor Ready, and while those cases weren't directly on point, it does show that this court is being faced with a very serious problem when it comes to employee leasing companies in the state of Florida. We all know that in the state of Florida, general contractors are responsible for the workers' compensation coverage of any uninsured worker on the job site. We know that when general contractors buy workers' compensation coverage, that the risk that there are uninsured workers on the job site is built into those policies. But what we have going on here is we have an insurance company, Crum Insurance Company, located at 100 South Missouri Avenue in Clearwater, who creates another company, Crum Services, again, located at 100 South Missouri Avenue in Clearwater. And they write a contract. And in this contract between their Crum Services and any employers that they want to provide services to, they carve out exceptions. Well, under the Florida workers' compensation law, the courts have never allowed employers to carve out exceptions. They've never allowed them to make claimants pay for workers' compensation insurance. And in the Gator Freightways case, which was before the Supreme Court, it was a case in which, again, there was a contract between the company and someone that they hired as an independent contractor, which the contract actually said that independent contractor is not going to be provided with workers' compensation coverage. They are an independent contractor, not an employee. But Gator Freightways said, no, it doesn't work that way, because under 440.10, there is responsibility for those who are either your subcontractors or, in this particular case, who are working on the job site. We cannot allow, as a state, insurance companies or employers to carve out exceptions for coverage on a work site. When we had the legislature amend the law in 2003, they actually amended the definition of employer to include employee leasing companies. And they also tried to firm up these loopholes in situations where general contractors are not providing for insurance.
So, counsel, the employee leasing agreement was, that is, the validity of this employee leasing agreement was not an issue in the proceedings below.
Well,
why
actually,
is it an issue in these proceedings?
Actually, I do believe that trial counsel did, through the testimony of John Harrington, who was counsel for Crum, attempt to argue before the JCC that in not retaining or in just retaining their rights to go on to the workplace premises to check up on things that they're entitled to under 468, he did argue that this leasing contract was not actually in compliance with the intent and the legislative intent of the law. See, this entire situation, while the appellants want to say that they didn't need to exercise their right to go on to the workplace, this entire situation could be avoided if they did, in fact, exercise that right. They would know whether the ladder was faulty, as Judge Thomas alluded to. They would know whether there were uninsured employees on the job site. The fact of the matter is that Crum Services chose a partner to enter into a contract with who was not a very good partner, who did not abide by the terms of the contract. But the claimant is not a part of that contract. The claimant is an uninsured worker on a job site. And what Crum did, and what the record establishes that Crum Services does at least many times, is they entered into employee leasing company contracts with general contractors. Now, appellant wants to talk about public policy. Well, surely I would submit to this court public policy cannot be served by carving out a giant loophole to allow general contractors to contract with an employee leasing company and thereby have uninsured workers on their job site which have no coverage. That can't possibly be what public policy is.
Counsel, in the Fred Stevens Tree Company case, we talked about the fact that equitable estoppel may be a basis for finding that the claimant was the employee of the leasing company. And there were a series of facts there about the practice of faxing in the employment paperwork. Are there any facts in this case similar to that?
They're not. And Judge Van Nortwick, I'm aware that you were on that panel, and I'm sure you're aware that I was the trial counsel and the appellate counsel on that particular case. And it involved a completely different issue. Again, another problem with the employee leasing company who is not recognizing an employee whose paperwork was not faxed in. But in that particular case, the facts that I saw them as trial counsel were so persuasive as to the manner in which this contract was being played out that I felt that the doctrine of equitable estoppel fit directly into those facts. Now, Judge, you also wrote the opinion in the case that we can't pronounce, the Labor Ready case. And within your opinion... I couldn't
pronounce it then either.
Within your opinion, you wrote that the broad language of these provisions, and that, of course, is referring to the statutory definitions of employer and employees under 440.02, that the broad language of these provisions reflects the intent of the legislature to afford expansive reach to employee coverage under Florida workers' compensation, subject only to narrow exceptions. Now, this case wasn't directly on point either, again, involving another situation with an employee leasing company, but this case really revolved around the jurisdiction and whether there was jurisdiction in the state of Florida or whether there was jurisdiction in the state of Alabama, and this court found that the jurisdiction in the contract was made in Alabama. So, again, another case involving these issues, but not directly on point. What I was going to say before is that when the appellants plead to this court that Crum Services doesn't get any money for this employee, or Crum Services didn't know Mr. Soto, this is no different than the cases that this court has struggled with for decades. That being when general contractors are required to pick up the coverage, or their workers' compensation carrier is, for uninsured workers, uninsured subcontractors on their job site. This is nothing new because the public policy in this court is to put the burden of injuries on the industry, not the burden upon the taxpayers through having to pay their bills or having to provide them with welfare payments, but it's on the industry. And I would submit to you that just as in the Gator Freightways case, this court cannot allow a company to come in here, create their own company, an insurance company creating their own employee leasing company, rewrite the definition of employer, rewrite the definition of employee, and have workers going out on job sites through no fault of their own, through no knowledge, knowing or finding out that there is no workers' compensation coverage. There is no case directly on point in the state of Florida on this issue. As I've indicated in my brief, I looked for it outside this jurisdiction, and the only case that came close came out of California. But this is a very important issue, because if this court were to reverse and thereby write a written opinion, the loophole would be enormous. Every general, well, I don't want to exaggerate. I don't want to be too gloom and doom, but employers, general contractors who have difficulty obtaining workers' compensation coverage, we know that to be true, would be able to just simply pass the buck through entering into an employee leasing arrangement and end up with no coverage for subcontractors and employees on the job site, just as what occurred here.
Counsel, isn't the specialized decision from this court from 1999 that Judge Webster authored, isn't that case closely analogous, if not at least as a legal principle, directly on point, where we ruled that a person was not subject and was not an employee of the lease company?
Well, I think the circumstances there were different. They were distinguishable, and I think we're seeing between 1999 and 2007, we have seen an amendment to the Workers' Compensation Act, a drastic amendment in 2003, and an amendment which did attempt to bring in these uninsured employees and was directed towards the construction industry. In addition, we have the interplay of Florida Statute 468, which governs employee leasing companies. So I think that while there is some indication, the facts here are distinguishable, and it is a problem that is coming before this court in more and more ways. Each of these cases that we've talked about, which were involving employee leasing companies, they all almost dealt with employers who had not faxed or provided information to the employee leasing company prior to hiring the claimant, they're coming here based upon different facts and different legal theories, just as in the Fred Stevens case versus Harrison came before this court on equitable estoppel. But it is a problem that is growing, and entering into a written opinion which allows this loophole is really something that is unconscionable. It is unconscionable to allow this situation, general contractors, to be allowed to have no coverage for these employees. And
but counsel, is this an issue that should be addressed by the legislature as opposed to this court?
Well, I wish the legislature would address this issue. I really do. But I think that, unfortunately, as these cases have become more and more prevalent in time, I hope to see the legislature deal with it. But when we talk about Florida Statute 440.10 and we talk about subcontractors and general contractors, the law has evolved over the years despite the fact that the statute hasn't changed. But there's really nothing that has been done by the legislature. But, you know, I would also indicate to this court that, you know, Crum Services has a remedy here. Okay? Their contract, which is part of the record, indicates an indemnification between P&G and Crum Services. And I would respectfully submit to the court that Crum Services becomes the employer, Crum Insurance becomes the carrier, and if they're not happy with that because the contract was broken, that issue is properly before the circuit court between Crum Services and Crum Insurance and P&G. They have an indemnification policy. It's a contractual issue. The issue before this court should be whether there is coverage on a work site.
So if we wrote an opinion of affirming, we would establish, would we not, that notwithstanding the contract between the leasing company and the employer, the general contractor, any employee hired by the general contractor is covered, notwithstanding whether they complied with the contract provisions or not.
Well, that is feasible, but I would submit to this court that that ruling, if the court were to rule in that way and write the opinion in that way,
the effect of the rule?
Right, is really no different than Gator Freightways, in which the Supreme Court said, we don't care what the contract says. The contract says that this guy Reason is an independent employer. Reason hired somebody else who was, again, an independent employer, but, you know, the court found under the applicable statutes that it was subcontracting work or it was through the line of coverage, and basically found coverage for that particular employee.
And you make a very compelling public policy argument, one that as Judge Lewis has noted, is certainly appropriate to be made to the legislature. But assuming we were to rule in your favor, there's a compelling public policy argument, is there not, that what we're doing is essentially ruling in favor of P&G. And P&G gets a windfall benefit by committing, not in this case, but you can certainly see, and I know based on your insight and candor on other points you've already addressed here today, that certain contractors would and could commit fraud by entering into employee leasing contracts and then simply not complying with the terms of the contract.
You are absolutely correct, and I think that has been going on for decades without the employee leasing contracts, and that's why the statute provides coverage for those down the line. But again, this contract, Crum Services entered into a contract with P&G. Perhaps they were a poor partner to enter into a contract with. But Florida Statute 468 does provide Crum Services the ability to supervise these work sites. And the workers' compensation statute has always provided workers' compensation carriers to audit at the end of a year. Even taking this outside the scope of general contractors, say my law firm has workers' compensation insurance. My carrier could decide at the end of the year they want to see exactly how much payroll I have as opposed to how much payroll I had foreseen at the beginning of that contract. They could audit them. They could get their money back. But more importantly, in this case, they were indemnified. They could go sue P&G in the circuit court under that particular contract, and I would submit to this court that the contractual issue is better served in the circuit court, and the public policy in this state is to provide coverage to an unknowing employer or employee who falls off a roof.
But in this case, of course, the contractor has refused to honor a subpoena. So in this particular case, we're addressing a situation where to announce a rule either way, it's unavoidable to say one party, either the claimant or Crum Services, is going to be left without a remedy. Because in this case, it's crystal clear, is it not, from the record, that P&G has essentially absconded from the litigation, if you could put it that way, that they have not responded to the subpoenas, and contempt proceedings were certified to the circuit court, right?
Yes, but again, this is not a situation that these courts have not seen under, basic general contracting law before. I think it's an analogous situation, and I think that public policy is served by providing the coverage. But, I understand the wrestling with it. I wrestled with it as the appellate attorney trying to, determine where this exactly falls within the statute. But basically, I think that the judge of compensation claims needs to be affirmed on this particular issue. And then when the issue comes up about these employers not reporting to their employee leasing companies, then it's an issue where the workers' comp coverage goes up and takes into effect the risk that general contractors have been paying for workers' compensation insurance. I mean, they're basically able to provide workers' compensation coverage at a lower cost, and that's the attraction for a general contractor, then a general contractor would be able to go out and get on their own, because that insurance covers the risk of that general contractor not complying with the statute and making sure that the subcontractors have insurance.
So if we were to rule, and assume we affirm the JCC in this case, what effect would that ruling be on employee leasing agreements? Will we be in effect ruling those employee leasing agreements a nullity?
I'm sorry, the employee...
Would the effect of that ruling be, in terms of employee leasing agreements, to rule they are basically a nullity?
I don't think the agreement is a nullity. I still think that portions of the contract can be asserted in circuit court between the employee leasing company and the client company that they contract with. I think, obviously, if you were to affirm this ruling with a written opinion, I think we would see employee leasing companies all of a sudden exercising those rights that the legislature has required them to retain in making sure that the job site is safe and making sure that there aren't any uninsured workers on it.
Can I ask a question?
Sure.
Then if I may ask, obviously, Article 2, Section 3 of the Florida Constitution looms when a court is asked to essentially reach a result that is not directly supported by a statutory citation. I mean, there's no statute making Crum Services the employer in this case, so I assume your answer to what authority we would have to do that would be Gator Freightways.
It would be Gator Freightways, and I would submit to this court that Crum Services stepped into the shoes of P&G, who happens to be a general contractor. If they don't want to insure general contractors who are subject to providing insurance or workers' compensation coverage to uninsured workers on their job site, you simply don't enter into a contract with a general contractor. Thank you, Your Honors. Appreciate your time.
Ms. Curtis, we ran over a good bit on the appellee's argument, so we'll give you an additional couple of minutes, so it'll be a total of 3 minutes.
All right, thank you, Your Honor. Your Honors, I think it's important to point out a distinction here. FWC Insurance did not write a policy of insurance to P&G. FWC Insurance provided insurance coverage for leased employees of Crum Services. The privity of contract here exists between Crum Services and Frank Winston Crum Insurance, not Frank Winston Crum Insurance and P&G. The appellee is submitting that Crum Services, in drafting this contract, was attempting to carve out exceptions to employee-employer relationships. This is not a contract that some general counsel of Crum sat in a back room and drafted. This is a contract that has to be approved by the Employee Leasing Board, that has to comply with statutes that regulate the employee leasing companies, and virtually every employee leasing contract contains this exact language that we're discussing.
But from a practical point of view, not necessarily anything covered by the statute, isn't the problem with that is that general contractors, unsophisticated in insurance, come to an insurance company and say, I want workers' comp coverage. And what they get is a leasing arrangement which has a gap, as I think Crum's general counsel testified to. In order to have complete coverage, P&G should have had coverage in addition to the leasing arrangement to cover anyone in this gap period before they were picked up. My guess is no general contractor, or certainly a very low percentage of general contractors in Florida, know about that. And so what happens is we end up with uninsured workers. Now, is that logical?
Your Honor,
consistent with the statute?
Your Honor, it's consistent with the statute in that the statute addresses that very situation. When a general contractor doesn't have insurance, that general contractor does have to be responsible for the underlying accident. However, that general contractor has certain duties to check the job site, to make sure that there aren't any uninsured workers on that job site. Counsel for the appellee suggests that a simple solution to this problem would have been if Crum just exercised their right. That's an unduly burdensome right to exercise in every situation, and then you're not going to be able to catch every situation as an employer. A better simple solution to this problem would have been submit the paperwork on Mr. Soto Lopez to Crum, and they would have picked him up as a leased employee, just as Del Sol was a leased employee, and they would have paid for this accident. But that wasn't done here, and because that wasn't done here, the appellee is trying to circumvent that and hold the collectible defendant responsible for the benefits contained in the workers' compensation statute. Now, Your Honors noted the Hazel Ferrier case, and in that particular case, while this court did indicate that it should be broadly construed, the definition of employee-employee relationship should be broadly construed, this court also opined at page 604, citing Tulane Investments Incorporation versus Orr, 889 Southern 2nd 961, out of this court in 2004, that in Hazel Ferrier, had the employee leasing company failed to provide workers' compensation coverage, the workers' compensation liability would attach to the special employer. And in this case, that would be P&G. This court specifically addressed that. And Judge Thomas, you were correct in that specialty leasing also specifically addresses this situation. This court found that in specialty leasing, if there is no employment relationship between the leasing company and the injured worker on the date of accident, then the actual employer becomes liable for providing workers' compensation benefits. And that is in the specialty leasing case at page 1172.
Counsel, your time's expired.
Thank you, Your Honor.